Hi, welcome to Module 32 of your Intellectual Property course. This module will look into compulsory licensing of patents as well as other uses of patents without authorization. As you would have seen in the first part of your course, patent regimes are configured so as to foster a delicate balance between private exclusionary rights on one hand, which are meant to incentivize innovation, and on the other hand, a public or social interest in accessing that innovation at affordable rates. Ensuring that this balance is achieved requires nuanced exceptions and limitations on the broad patent right that is generally granted to the right holder. Part of this configuration is the inclusion of use without authorization licensing mechanisms. This allows the diffusion or dissemination of the innovation even when the right holders refuse to voluntarily engage in such action. Examples of situations where this is done is when the patent holder's behavior is seen as abusing their patent rights, or when the countervailing interest is seen as significant enough to justify an interruption of the right holder's patent duration. As seen in slide number 2, an example of this is when, say, an MNC pharma company has a patent over a drug but doesn't sell the drug in India. This often happens because they want to protect their right in India, but they haven't gotten around to marketing that drug in India or developing the drug for India, or they might not see India as a market which is valuable enough to invest into marketing that drug in India. However, this also prevents generic companies in engaging in such behavior. If, in case the MNC pharma company does not license that patent to generic companies, this could be seen as an abuse of their patent right. So one major method of achieving this balance is the inclusion of these quote-unquote use without authorization licensing mechanisms. It's relevant to note the history of how this came about. After the first substantive harmonization which occurred with the adoption of the WTO TRIPS agreement, countries were required to ratify the TRIPS agreement if they wanted access to the global trading regime. This, of course, ensured that membership was very widespread, with nearly all countries wanting to access the global trading regimes, and then this led to substantive norms being harmonized across all member countries. In the background, however, decisions on what went into the draft on the TRIPS agreement were very controversial. Developed countries demanded much more stringent norms for intellectual property, while negotiators from developing countries, especially India and Brazil, did not have such norms in their countries earlier and did not want to give in to accepting such stringent norms for their countries, which were still poor and developing. So what they did was they demanded flexibilities to ensure that the populations in their countries were not priced out by the exercise of patent rights from incoming multinational corporations, especially in crucial sectors such as public health. In what was arguably one of the biggest wins for developing country negotiators were provisions allowing for certain uses of patented products without authorizations from the patent holders being introduced into the text of the TRIPS agreement. Of these various use without authorization licensing mechanisms, compulsory licensing is by far the most prominent. The field in public health in particular has been the most visible in this innovation access tension. The other types include government use, experimental use, and BOLA exemptions. You can see these forementioned on slide number 3. Let's first look at these mechanisms as they exist under the TRIPS agreement. As earlier chapters would have shown, patent law and policy can be structured so as to include broad exclusions in terms of patentable subject matter, robust patentability criteria, pre-grant and post-grant oppositions, all of which can contribute towards carving out a patent regime that ensures only genuine innovations are rewarded with patent rights. Nonetheless, there are situations where patents can inhibit access to important products, and permissions of rights holders cannot be permitted to block out the licensing of that product to generic manufacturers. It is for these circumstances that compulsory licenses and other unauthorized uses were introduced, and these are some of the most widely recognized TRIPS flexibilities against patent monopolies. Even prior to the substantive harmonization brought about by TRIPS, however, compulsory licensing has been steadily cementing its place in the legal regimes of countries across the world, including in India. Article 31 of the TRIPS Agreement is a provision which allows for the government grant of a license to a third party to use a patent without the consent of the patent holder. It's interesting to note, though, that the phrase compulsory license doesn't actually find a place in the agreement. Instead, the broader phrase other use without authorization of the right holder is used. Thus, compulsory licensing is only part of the non-voluntary licensing agreements envisioned through this article. Government use is the other main type of unauthorized use covered by Article 31, and apart from these two, there are certain exceptions that function in the nature of unauthorized use, even though they technically find backing under Article 30, which is titled Exceptions to Rights Conferred. These are the research exemptions and BOLA provisions, as earlier mentioned. As described in slide number 4, compulsory licensing can be defined as the legally enforced mechanism through which patent holders are forced to license out their statutorily granted patent rights to third parties capable of fulfilling the reasonable requirements of the public by manufacturing the patented product at cheaper prices. Looking at Article 31, it does not define situations or cases in which a compulsory license can be granted, but rather sets out specific conditions for the grant. These are non-exhaustive, but they include prior negotiations with the rights holders. This means that the applicant must have attempted for a reasonable amount of time to have obtained a voluntary license on reasonable commercial terms. After having attempted this for some time and have failed with obtaining a voluntary license, then they can apply for a compulsory license. This is not required in cases of national emergency, other cases of extreme urgency, or public non-commercial use. It is also not required when a judicial or administrative body has granted the license for anti-competitive practices by the right holder. However, it is required that the patentee be notified as soon as reasonably practicable. The next condition is that if such non-voluntary license issues, then the patentee must receive adequate remuneration, taking into account the economic value of authorization. Further, in instances of non-authorized use that fall under this part, Article 44, subsection 2 limits the patentee's rights to remedies to this remuneration only. The next condition looks at the circumstances under which the compulsory license was granted. If these change and no longer validly justify the license and are unlikely to recur, then the license is to be revoked. Next, the scope of the grant must be limited to the purpose for which the license is conferred. Moving on, the licenses must be non-exclusive, non-assignable, and must be granted predominantly for the supply in the domestic market. However, if the license is granted due to anti-competitive practices by the right holder, this last condition is not necessary. Continuing on, the next condition says that there must be an independent reviewing authority to which the right holder can approach an appeal. And finally, where the license is for a dependent patent, that is, where authorization to a prior patent is required to work the latter patent, additional conditions include that the latter patent involves an important technical advantage of considerable economic significance as compared to the prior patent. Secondly, that the rights holders of the prior patent be entitled to cross-license on reasonable terms. And thirdly, that the use authorized for the first patent be assignable only with the assignment of the second patent. As can be seen, the agreement does not provide an exhaustive list of situations in which a non-voluntary license can be granted, nor does it limit the grounds for such licenses. Rather, it indicates possible grounds and sets conditions for the grant of a compulsory license. Therefore, the language in Article 31B, which mentions national emergencies, etc., as per when voluntary licenses negotiations are not required, does not limit the grant of compulsory licenses to those grounds alone. This was further clarified by the Doha Declaration, which specified that the member states have the freedom to determine the grounds upon which the compulsory licenses are granted. It also went on to state that member states have the right to determine what constitutes a national emergency or situation of extreme emergency, and that public health crises include those relating to HIV/AIDS, tuberculosis, malaria, and other epidemics can represent a national emergency or other circumstance of extreme urgency. As the compulsory licensing provision was largely seen as one that was meant to ensure countries could remedy public health emergencies and ensure access to medicines for the populace, several countries without local generic manufacturing capacity protested the provision which mentioned that licenses needed to be predominantly for the supply of the domestic market. This led to Para 6 of the Doha Declaration and the August 30th decision in 2003. You can see this in slide 7. As mentioned in slide 7 of the presentation, Para 6 of the Doha Declaration and the August 30th decision allowed countries with local manufacturing capacity to export drugs to countries with public health needs, thereby waiving the predominant supply to the domestic market requirement. While discussing non-voluntary licenses under Article 31, it is also useful to look at exceptions to rights conferred as described under Article 30, as the spirit of the provisions are very similar to each other, and the ambits may even sometimes overlap. Article 30 states that limited exceptions may be provided when they do not conflict with normal exploitation of the patent and do not unreasonably prejudice the legitimate interests of the patent holder, taking into account the legitimate interests of third parties. This has been recognized as a source of two types of exceptions: experimental use exceptions and Bowler exemptions. Experimental use exceptions under this provision enable experimental use with registered patents and allow implementing countries to encourage the understanding and absorption of underlying technologies. Similarly, the Bowler exemption provisions permit third parties to manufacture and use a patented product for the purposes of obtaining information necessary for marketing approval. This allows third parties to bring their products to the market as soon as a patent expires. A WTO panel, in the case Canada Patent Protection of Pharmaceuticals, has ruled on the Bowler exemptions in 2000, holding it as compatible with the TRIPS agreement. In both these exceptions, the normal exploitation of the patent is not interfered with, and interests of the rights holders as well as third parties are balanced appropriately. Let's move on to compulsory licensing in India. This is slide number 8 of your presentation. Its compulsory licensing regime in India is broadly encapsulated in Chapter 16 of the Patents Act from sections 82 to 94. They can broadly be categorized as abuse of patents and number 2, public interest requirements. Let us first look at number 1, abuse of patents. Section 84 of the Patents Act states that any party interest may apply for the grant of a compulsory license on the following 3 grounds. First, that the reasonable requirements of the public with respect to the patented invention have not been satisfied, or second, that the patented invention is not available to the public at a reasonably affordable price, or 3, that the patented invention is not worked in the territory of India. Thus, the 3 grounds are reasonable requirements of the public, or reasonably affordable price, or not worked in the territory of India. Any application for the grant of a compulsory license under Section 84 must contain at least one of the above grounds. It is also relevant to note, however, that these concepts can be overlapping, and that is, one may lead to another. Prior to the grant of a compulsory license, though, Section 84(6)(4) of the Patents Act requires that the applicant has made efforts to obtain a voluntary license from the patentee on reasonable terms and conditions, and that such efforts have not been successful within a reasonable period as the controller may deem fit. This is later clarified that the reasonable period does not ordinarily need to exceed a period of 6 months. Let's look at the first case, BDR versus Bristol Myers Squibb, BMS for short. In March 2013, BDR filed a compulsory license application under Section 84 of the Act for dasatinib, that is an anti-cancer drug whose patent was held by BMS. This was only the second compulsory license application to be considered under the section till then. BDR first sent a letter seeking a voluntary license on 2nd February 2012, and BMS responded to this on 13th March 2012. In their response, BMS set forth a list of questions regarding whether BDR would be able to work the patent. However, BDR did not send a reply to this and directly filed a compulsory license application the next year. Now, as per Rule 97 of the patent rules, the controller is to notify the applicant if he or she is satisfied that the prima facie case is not made out. The controller accordingly notified BDR that it had failed to make out a prima facie case for the grant of a compulsory license on two grounds. First, the failure to make reasonable efforts to obtain the license from the patentee, and secondly, the failure to obtain regulatory clearance for the drug. Hence, it was denied. Now we move on to reasonable requirements of the public. The test of reasonable requirement of the public is found in 39 of 41 prominent developing countries. It's also mentioned in the Paris Convention, which says the lack or insufficient working of the patented invention is a ground for the grant of a compulsory license. Looking at the Indian legislation, certain acts are deemed as failing the test of whether reasonable requirements of the public have been met. These include, firstly, if by reason of refusal to grant a license on reasonable terms, the continuance or development of an existing trade or industry, or the establishment of a new trade and industry is prejudiced, a compulsory license shall be granted. Secondly, if the demand for a patented article has not been met to an adequate extent and on reasonable terms, a compulsory license may be granted. Thirdly, if a market for export of the patented article manufactured in India is not being supplied or developed, a compulsory license may be granted. The ambit of this provision remains unclear, however, as does its TRIPS compliancy. This is because Article 31F of the TRIPS agreement, which requires that a compulsory license be granted predominantly for the supply in the domestic market. However, Section 90, subsection 1, subsection 7 seems to qualify this provision by stating that the controller shall endeavor to secure that the license is granted with the predominant purpose of supply in the Indian market. However, the same subclause also refers to Section 84, 7A3 for terms on which an export license may be given if need be. It must be noted that as per the Doha Declaration and its implementation decision, exports of pharmaceutical products to countries with no manufacturing capabilities is permissible. Then the next test looks at if by reasons of conditions imposed by the patentee upon the grant of the licenses or purchase or hire or use of the patent, the manufacture, use or sale of materials not protected by the patent, or the establishment, development of any trade or industry in India is prejudiced. If this happens, then a compulsory license may be granted. Moving on, if there are coercive and grossly unfair licensing terms, such as exclusive grant-back or prevention of challenges of validity or coercive packaging licensing, etc., these are also conditions under which a compulsory license may be granted. And then, if the patented invention is not worked on a commercial scale to an adequate extent in India, Section 83 describes the general principles for interpretation and also talks about the working of the patented invention on a commercial scale. If the working of a patented invention on a commercial scale in the territory of India is being prevented or hindered by the importation from abroad of the patented article, a compulsory license may be granted. Now we'll move on to the next requirement, that is reasonably affordable price. Section 84(1)(b) requires a determination as to whether the price at which the patented product is made available to the public is reasonably affordable or not. This can be decided on a case-to-case basis. However, the IPAB held in Bayer v. Natco that a determination of whether a price is reasonably affordable to the general public does not hinge upon the cost of the product, but is rather determined from the consumer's perspective of whether the product is or is not affordable. We'll discuss this case a little later in more detail. But we'll now move on to the third requirement, that is working of the patent within the territory of India. Section 84(1)(c) provides that an application for a compulsory license can be made when the patented invention is not worked in the territory of India. In Bayer v. Natco, the IPAB linked this working requirement to the earlier ground listed in reasonable requirements of the public. However, as just mentioned, the decision by the IPAB then went on to hold that import could amount to working and is to be decided on a case-to-case basis. However, if we look at Section 83, it indicates that the controller at the Patent Office may have held an interpretation that is more consistent with the legislation. This is because Section 83(b) and (c) state that patents are not granted merely to enable patentees to enjoy monopolies for the importation of patented articles, and 83(c), which states that the protection and enforcement of patent rights contributes to the promotion of technological innovation and to the transfer and dissemination of technology. As Article 27 of the TRIPS agreement mandates no discrimination between locally produced and imported patented products, there have been questions about whether a local working provision would be a legitimate one at all. This question was brought up in a WTO challenge by US to Brazil's patent regime, which included a similar local working provision. However, the case was eventually dropped, so there was no ruling on this. Arguably though, such a provision would be a valid one. In the Canada Patent Protection of Pharmaceutical Products case, the WTO panel held that discrimination refers to unjustified discrimination, thus allowing for justified differentiations, if any. As the Paris Convention, as incorporated into the TRIPS agreement, clearly draws a distinction between working and importing, there is an indication that non-working, and even if importing, could be treated as an abuse of patent. Further, a local working provision is more in sync with the promise of technology transfer that the TRIPS is premised upon. It has to be noted that a local working requirement does not necessitate the setting up of a manufacturing unit by foreign companies, as licensing the manufacture to local companies could also be used to fulfill this requirement. Now we'll look at the next case law, that is the Natco-Bayer compulsory license issue. This was a landmark case in India, as it was the first compulsory license granted. It was granted over Bayer's patented drug Nexavar. In August 2011, Natco, an Indian generic company, applied for the grant of a compulsory license for the anti-cancer drug Nexavar. On March 9, 2012, the Indian Patent Office granted the first post-TRIPS compulsory license in respect of this drug. This drug was used for treating kidney and liver cancer. The Indian Patent Office granted the license to the Natco Pharmaceuticals, enabling it to produce and sell the drug domestically on condition of payment of royalty at 6% quarterly royalty of net sales. The Indian Patent Office held that all three grounds mentioned in Section 84 had been met, namely that the reasonable requirements of the public were not met,
as Bayer supplied the drug to only 2% of the patient population of about 8,800 that required it. Secondly, the drug, priced at rupees 2,80,000 for just a month's supply, was not reasonably affordable. It's relevant to note that Natco was willing to supply the same at rupees 8,800 per month. And thirdly, the patent was not worked in the territory of India, as Bayer did not manufacture the drug in India but merely imported it. Bayer took this in appeal to India's Specialized IP Tribunal, the IPAB, and on March 14, 2013, the IPAB upheld the license and confirmed all three grounds mentioned in the order of the patent controller, though there were some differences in how the decisions were reached. Notably, the IPAB also held that even though the grounds in Section 84 were separate and individually sufficient as causes for the grant of a compulsory license, the grounds were linked such that the failure of one ground would likely trigger another ground. Looking into the reasonable requirements test, the IPAB considered the following factors when making their decision: the need for the drug in terms of patient pool, the volume of the drug supplied by Bayer to the market, with both its patient assistance program as well as without the program, the effect of the price on the availability of the drug to the public. The IPAB found that the price of rupees 2.8 lakhs per month was prohibitively expensive, especially in contrast to Natco's price of 8,800 per month. Then they looked into whether Bayer's patient assistance program could be considered as contributing to Bayer's standard for working, and found that only commercial use was relevant to whether the reasonable requirements of the public were being met, as subsidy programs, being voluntary and insufficient, were unable to meet this requirement. The volume of imports by Bayer, and found that the volume was sufficient to meet only 2% of the needs of patients. And finally, whether local manufacture was required to be considered working of the patent. And the IPAB held that even if only imports were considered, the volume still did not meet the requirement of the public anyway. Thus, on considering all the above factors, and on finding that the insufficient numbers and prohibitively expensive product held that Bayer was not satisfying the reasonable requirements of the public for the drug. The IPO, the Indian Patent Office, and the IPAB both held that determination of whether a price was reasonably affordable to the general public does not hinge on the research and development and other related costs of the drug, but rather whether the drug is reasonably affordable from the consumer's perspective. Further, the controller and the IPAB also held a reasonably affordable price strongly correlates to whether or not the reasonable requirements of the public are being met. Notably, the IPAB also mentioned that a company facing a compulsory license grant on this ground could escape this provision by revisiting their pricing. As for royalty rates, IPAB held that Natco was required to increase the royalty payment from 6% to 7%. The main point of differentiation between the IPO and the IPAB was whether worked in the territory of India could include imported products as well. The Patent Office held that mere imports could not amount to working, while the IPAB held that working requirement doesn't necessarily exclude imports, and therefore the mere imports could satisfy the working requirement, and that this needed to be decided on a case-to-case basis. With this, we end the abuse of patent type of compulsory license, and we move on to the public interest requirements based compulsory license. Section 92 allows the government to issue a notification in the official gazette that a compulsory license should be granted in respect of any patent, in cases of national emergency or extreme urgency or public non-commercial use. Following this notification, any interested party can apply and be granted a license on terms and conditions as the controller sees fit. Further, the controller is to ensure that the products manufactured under this license are made available at the lowest possible price, with the patentees deriving a reasonable advantage from their patent rights. These are broadly considered the public interest grounds. However, there is yet to be an explanation or clarification as to the extent of these terms. The section does specify, though, that included in these criteria specifically are public health crises related to acquired immunodeficiency syndrome, that is AIDS, HIV, human immunodeficiency virus, tuberculosis, malaria, or other epidemics. It is not necessarily limited to these, but it definitely includes these. As of the writing of this module, the government is considering a Section 2 notification for 3 drugs. Moving on, aside from abuse of patent reasons and public interest requirement reasons, there are also 2 more types of compulsory licenses under our legislation. These include the compulsory license for export of pharmaceutical products and compulsory license of mailbox application related products. First, we'll deal with compulsory licenses for export of pharmaceutical products. Section 92A was introduced in the 2005 amendment so as to implement the Doha Para 6 decision. Provided that a country with insufficient or no manufacturing capacity has issued a compulsory license over a patented pharmaceutical product, this provision makes a compulsory license available for the manufacture and export of such patented pharmaceutical products. When the controller receives such an application, the controller is to grant the compulsory license solely for the manufacture and export of such patented products under terms and conditions as specified by him. It is to be noted that this section is limited to pharmaceutical products, which are needed to address public health problems, including necessary ingredients and diagnostic kits. This provision has only come up once so far in the Indian context. In 2008, when NATCO, a leading Indian generic manufacturer, applied for a compulsory license under Section 92A to export 2 patented drugs to Nepal. NATCO submitted that Nepal was facing a public health crisis and lacked the manufacturing capacity to produce the required anti-lung cancer drug. However, on a hearing granted to the patent holders, which were Roche and Pfizer, the Patent Office noted that Nepal had not issued any relevant public health crisis drug requirements. NATCO soon withdrew its application after this. The next type of compulsory license finds its application even more limited. This is the compulsory license of mailbox application related patents. Section 11A(7) states that after a patent is granted in respect of an application made under the mailbox system, the patent holder shall be only entitled to receive a reasonable royalty from such enterprises which have made significant investment and were producing and marketing the concerned products prior to January 2005 and which continue to manufacture the products covered by the patent on the date of grant of the patent, and no infringement proceedings shall be instituted against such enterprises. This means that generic manufacturers who are producing drugs in relation to which patent applications are or were pending by way of the mailbox system can continue such manufacture with the grant of a patent to the applicant without being sued for infringement. The onus of negotiating reasonable royalties lies on the patentee. Thus, in the much discussed Novartis versus Union of India case, even if the court had upheld Novartis's patent, Cipla would be able to continue manufacture of imatinib, provided it paid reasonable royalties to Novartis. The question of what constitutes reasonable royalty still remains open. Now we move on to the next type of non-authorized use licenses. That's government use and other unauthorized uses in India. Looking at government use, aside from compulsory licenses, as mentioned earlier, Article 31 also envisages non-voluntary licenses in the form of government use licenses. In the Indian legislation, this is covered by Chapter 17. This includes sections 99 to 103 and also in section 47. which provides that in certain cases the government can use a patented product without infringing upon the product. Chapter 17, which is titled Use of Inventions for the Purpose of Government and Acquisition of Inventions by the Central Government, allows the central government to use a patented invention for the purposes of the central government, state government, or government undertaking on terms of remuneration similar to that of compulsory licenses. Unlike compulsory licenses, though, these provisions can be attracted even at the application stage rather than solely after the grant of the patent. Of course, even here, the remuneration clauses remain the same. The government will be free to sell such licensed products on a non-commercial basis. Section 47(4), on the other hand, is a conceptual supplementary provision to Section 92A. Compulsory licenses, that is, pharmaceutical products for export, permit the import of any patented medicine by the government for purposes merely of its own use or for distribution in any dispensary, hospital, or other medical institution maintained by or on behalf of the government. Unlike other government use provisions, though, this provision can be attracted only after the grant of the patent. The next type of non-voluntary license is the experimental use exception. The Indian patent regime makes use of flexibilities provided by Article 30 of the TRIPS Agreement. By implementing an experimental use exception, the regime allows third parties to fully understand and study products that have been granted patents, rendering a holistic satisfaction of the reason for the disclosure requirement. That is, that patent applicants must fully describe and disclose best methods of working of the patents that the applicant is seeking. Indian law is a broad interpretation of this experimentation provision, as it not only allows any person to make use of the experimental exception for purposes of experimentation or research, but specifically includes the imparting of instruction to pupils within the exception. As this falls within the Article 30 requirement of not unreasonably prejudicing legitimate interests of the patentee and normal exploitation of the patent, this does not fall afoul of India's TRIPS obligations. Given that TRIPS aims to ramp up the technological capabilities of developing countries, this sort of a broad interpretation also furthers its objectives by encouraging the development of follow-on inventions and improvements, as well as encouraging the inventing a round of patented inventions. And finally, we come to the last type of non-voluntary use license, that is the bowler exemption. As described earlier, Article 30 allows for the existence of bowler exceptions. This exception especially is relevant to the pharmaceutical field. It takes its name from the American case Roche Products versus Bolar Pharmaceuticals. Bolar Pharmaceuticals had successfully made the public policy argument that parties should be allowed to obtain information necessary to procure regulatory approval for a generic so that they could be ready to launch as soon as the patented drug's period expired. Section 107A provides for the exception in Indian law. This is especially relevant in India due to India's large generic pharmaceutical industry. It can be noted that the exception also allows exempt usage when information is sought to gain regulatory approval outside of the country. And with this, we conclude our chapter on non-voluntary licenses. For a quick recap, we've seen that India uses a wide range of TRIPS flexibilities in a domestic law, and of which compulsory licensing has garnered some of the most attention. The pharmaceutical and healthcare field is the best example. Because of the unique position that India finds itself in, India has to balance the concerns of a huge growing industry along with the access concerns of a largely poverty-stricken mass as well. As this chapter has shown in the area of non-voluntary licensing, where patent rights come in conflict with larger social concerns, India has carved out a well thought out and nuanced patent regime. Very briefly, stemming from Article 31 are Sections 84, and that is patent abuse, and Section 92, that is public interest exceptions, as well as government use exceptions, as under are Sections 99 to 103 and Section 47. Stemming from Article 30 of the TRIPS, are tangential but still very relevant experimental use exceptions as well as the Bowler exemptions. And with this, we conclude our chapter on compulsory licenses. Thank you.